who will be answering the questions for clearing our conception on the bill. Once I'm done with the set of questions, the other participants can move forward with their questions, and I'm sure sir will be obliged to answer them too and clear all our doubts. A very good evening, sir. To begin with, since we see that this farm bill has seen so much protest, so when a bill is being challenged, the first thing that comes to our mind is that was the legislation that was passed, did the legislature have the competency to pass it? To amend
Pressing
the
issue in the
previous
country today.
agriculture setup and bill
And
bills.
almost, I think, every newspaper and most of the media channels are covering it. It's also trending on social media. And you've started the very pertinent question as to whether the central government can impinge on the boundaries of the state government. But before we go there, let's understand the basic modalities and the boundaries that the Constitution has set up. So when we think of Farm Act, and there are two new Farm Acts which have been now promulgated and have made into an act, and one is an amendment to the Essential Commodities Act. So these three acts put together are being called Farm Act. Let me also quickly tell you the full form of these acts. The first act is the Assurance and Farm Services Act of 2020, and the other is the Farmers Produce Trade and Commerce Act of 2020. The third, as I said, is just a minor amendment to the Essential Commodities Act. Now, the Farm Act, in essence, is permitting the trading of agricultural produce in a particular trade area, which is defined as a region or as a place of production, collection, and aggregation, excluding market yards notified by the states under their respective Agricultural Produce Market Committees Act, which is popularly called the APMC Act. APMC is vernacular. Sometimes you also call it the Mandi Bazaar jo lagta hai. So earlier, the APMC Act, the transaction of sale could, normally take place only within the market area, and more specifically within the demarcated market and some market within the state, a particular state. And the state therefore levied a market cess on such transaction for sale, which formed the major source of revenue for them. Now, the current Farm Act seek to lift these geographical and economical compulsion under various sections of these two farm Acts and the sections which are put therein. The state object of APMC Act was the regulation of sale and purchase of agricultural produce and establishment, superintendence and control of the market. However, contrary to the popular perception, the APMC Act have been framed under Entry 14 List 2 of the Constitution dealing with agriculture. And the Supreme Court in Balsan Sugar Company Limited has traced the source of state legislative power behind APMC Act to be entries 26, 27, and 28 of List 2 of the 7th Schedule. Now, entry 28 of the state list relating to the markets and fairs enables the states to determine the location of the market and to provide for its management and maintenance simpliciter. Entry 28, however, by itself does not confer the power to the states to regulate sale and purchase of agricultural produce. The power to regulate and purchase is relatable to entries 26 and 27 of the state list, as I just mentioned before. Also, behind these legislative entries to deal with trade and commerce is state entry 26 for supply, production, and distribution of goods is entry 27. And currently, the center has formed it under the provision of entry 33 of the list 3, which deals with trade and commerce, and also the production, supply, and distribution of foodstuff and essential commodities. And that is how they have, bypassed the list 2 category in the given scenario. And the Farm Act, the two pertinent Farm Acts, which are regulating the trading and also the growth of the farm produce, they are finding their genesis in entry 33 entry 33 of list 3. And this legislation therefore do not per se deal with the agriculture or cultivation of farm produce, but they regulate trade and commerce of foodstuff and other essential commodities in a fair and transparent manner, so that to enable the farmers to draw maximum remuneration for their products. And we must also note that the wider meaning ascribed to foodstuff is already covered under these acts, and a good reading. And I must encourage your readers, please read these acts. They're only 8 pages acts. So the two acts combined together are 16 pages in the official Gazette of India. The 16 pages act, you can easily go through it. I think it should not take you more than 40-45 minutes to read these 16 pages and understand the law yourself. And just to add on to what I was already saying, is that the power to legislate is also traceable for the central government under Article 246, subsection 2 of the Constitution. And this has to be read along with Section 33 of List 3, which therefore gives the power to the central government to make these two laws. However, just to bring to the audience notice, obviously these farm laws have already been put to test before the floor in Supreme Court. And it's a matter of wait and watch, what the Honorable Supreme Court is now going to decide. And once they interpret various legislative mandate of the Constitution and various entries, it will be, I think, interesting to see how this pans out, and whether Supreme Court decides eventually that this should be in state domain, or should this be in central government's domain. But as I said, it talks about intra trade amongst different states also. So it talks about inter-trade, interstate trade, interstate trade, all those things. But yeah, to answer your questions, as preliminary saying, I would not say that the central government has bypassed the state laws or state legislature, or has tiptoed over the constitutional mandate which has been given. I think a careful scrutiny of the legislation would make you realize. I'm not saying the legislation is perfect, but all I'm saying is the way it has been drawn, to my mind, it does not impinge any constitutional mandate as of now.
Very well explained, sir. My second question would deal with something about which there has been a lot of hue and cry. That is regarding the minimum support price or the MSP. Now we know that these farmers are not very socially uplifted, so they are often exploited by certain middlemen and other people who are there in this business.
Right.
So earlier, when there was this concept of MSP, which encouraged the farmers to go for more yield, so that they had an insurance key. If I produce this much, this is the minimum support price I'm getting. But this new legislation has somewhat done away with the concept of MSP. So, what is the rationale behind doing away with MSP, and does it affect the farmers in its true sense?
So what we need to realize is that MSP is not defined in the Act, and what exists today is also something which is out of custom and state, or the central government support to the farmers. Let's understand for a second what minimum support price, or what we call MSP, is all about. So minimum support price is a safety net given to the farmers to ensure guaranteed prices and assured markets. This MSP-based procurement system is aimed to save the crops from price fluctuation due to various unwarranted factors such as the monsoon or lack of market integration, information asymmetry, and other elements of market imperfection plaguing the Indian agriculture. However, we do not have any, and I must repeat it, any legal backing for MSP. It's not even defined in these two acts. If you flip the acts, you would not find it in the definition column. So it's not defined. The three new farm laws also have not, as I said, have given this provision neither in the essential commodities or the two acts which have now been promulgated. And MSP normally is fixed twice a year on the recommendation of the Commission of Agriculture Cost and Prices, shortly termed as CACP, which is a statutory body, and it submits separate reports recommending prices of Kharif and Rabi seasons. The central government has so far, I think, began the fixing of MSP, or minimum support prices, for 22 agricultural produce, mainly, your paddy, wheat, moong dal, groundnut, soya bean, sunflower, mustard, and so on. So it is the price at which the government, is buys from the farmers for maintaining buffer stock for public distribution systems, so as to also maintain price stability in open market. And now that the farmers are insisting that the government makes MSP mandatory because they fear that it is not that it is will welcome the big corporates, and it could mop up their product at very cheap rates. So the government guarantee on MSP will ensure that they will not have to sell below a minimum price. But however, as I just told you, it's not a concept. It doesn't have a legal backing, and this is something which is not being discussed in any open platform or being legally told to people. I think a little more legal education, a little more webinars like these would make people understand what is the difference between a customary understanding of MSP and a legal, because there is no legality to it. So there is no legal definition of MSP as of date.
Thank you, sir. Moving on to the next question, which is that because there a dispute has arisen, there has been protest against these bills, and now that this dispute has been delegated to the bureaucracy, do you think that was the correct decision, or would setting up of a tribunal to address such kind of disputes or certain kind of forum would be a better approach to solve these disputes?
So I have two takes. Let me first take you through the acts quickly, how the hierarchy works, because there are two dispute resolution sections in both the acts. The first act, as I told you, is the Farmer Produce Trade and Commerce Act. The other is the uh, Farmers Empowerment and Protection Agreement on the Price and Assurance Act, both of this year, and they come into force, and I think from June 2020, having been signed in September 2020. Now the problem is when I was reading the act and I was preparing for your webinar, is there is no harm in giving the power to bureaucracy, because the power, and let's understand, there is no direct power which is being given. So let me tell you the first act. The first act is the Assurance and Farm Services Act. Under this, from section 13 to 15, if you read, it talks about dispute resolution. The first step under this act is conciliation. So the parties which are entering into dispute either because of payment or for sale of purchase, can feel free to have a conciliation of their own. They don't have to have a formalized conciliation structure. Now, if that conciliation fails, then the parties who are disputing with each other, whether it be the farmer or be the sponsor or the trader, then they can go and agitate their claim before the subdivisional magistrate or the SDM, as we popularly call them. Now, SDM has been given a power, just like in any other case, a power of a civil court to decide a matter, and all the provision of CPC to apply and this and that. Now, if they are not happy with the order of the SDM, the appeal would lie with the collector or the additional collector, and that's it. Because the civil courts are there under section 19 of this act, the civil courts are barred to try any of these cases. So bureaucracy, as you're saying, bureaucracy, that is the SDM, and the appellate power to the collector is being given. Now, any person who has sold or purchased land in the country would be aware that there is something called a mutation. So if there is a dispute regarding mutation or any other thing, it invariably leads in the court of the executive magistrate in most of the states across the country. So they are also called executive magistrate in laws. The judicial magistrate, they preside in the court, like the metropolitan magistrate or judicial magistrate of first class, and SDM is the executive magistrate, which who also holds their courts independently by the power entrusted to them under different acts. So when we are talking of farm acts, they have been given certain powers. Would it dilute the process of judiciary? I would say yes and no, and I'll tell you a practical example. Now, the problem is most of the time in bigger states, and I'm not talking of Delhi because Delhi is a union territory, but in most of the big states, or even in small states for that matter, a DM or a SDM, is most of the time traveling, because he has different charges or different areas or different districts under his belt. And that is a problem of concern, because even in normal parlance, if you have visited any SDM court, you would say कि साहब दौरे पे गए हुए. ऐसा कई बार सुनने को आता है. The collector or the SDM is on a tour because he has so many duties that he has to discharge or she has to discharge. And that is a problem. Why that is a problem? Because if a dispute lands up in the court by a farmer, who as it is, under problem, let's say a poor farmer, not a rich farmer, whose means are very limited. Now he will have to specifically go to executive magistrate. Then from there, he will have to go to a collector who may be sitting in a different city altogether, and then you are barring the civil court, which means the only next reprieve that he may have under law is perhaps a writ petition under Article 32 or 226 of the Constitution of this country. So imagine the plight of a poor farmer fighting litigation and going to different places. That is one problem. If they were to, and legally saying, there is nothing wrong, executive magistrate or a SDM deciding on this matter. As I told you about mutation, other cases, they deal with it on a normal basis. But I'm giving you a practical side of it. The second problem is that, let's say the civil courts were to be included and this act was to be amended. This would ease, I think, to some extent, the running around of a litigant. Because, a civil court, a civil judge would be presiding, a district judge would be presiding. So he would not have to go from city A to city B to city C to argue his appeals. He can just come to one premise and, argue his matter, because there are different talukas and district courts. There's a very robust judicial setup in the country already, since the time we have achieved independence. The other thing that we have to understand under these acts is, so this was under the first act, conciliation, SDM and collector, that's the hierarchy. Under the second act, which is the Produce, Trade and Commerce Act, there is no conciliation prior to coming to the SDM. So if you have a dispute regarding your e-trading or trading or transaction, you will go to the SDM office, you will file your complaint, and the SDM will then send the matter to conciliation. And that conciliation will act something like an arbitration, because one of the chairperson is going to be a government servant who is going to be appointed by the SDM, and the other two people will be nominated by one party each, which means, let's